It really is a rude jolt for the government's ambitious Aadhaar program. The Supreme Court today refused to give any interim relief to the centre, sticking to its earlier order limiting the use of Aadhaar cards for public distributor system and, of course, the LPG subsidy disbursement. In effect, the Supreme Court ruling shuts the door on financial institutions and regulators like the RBI, SEBI and also the IRDA, which were looking to make Aadhaar a single-point KYC tool. A three-judge bench of the Apex Court has, however, referred the case to a yet-to-be-set-up constitutional bench, which will deliberate on the finer points of law as far as Aadhaar is concerned.
The moot question is whether Aadhaar infringes upon one's right to privacy, with the government arguing that there is nothing like a fundamental right to privacy, and it's a double-edged sword. Either way, if the Constitution Bench allows the use of Aadhaar as a single-point KYC reference, it will undermine people's right to privacy. And if the final verdict goes against Aadhaar, it will defeat the government's ambitious plan to ascribe a unique identification number to every Indian. The Aadhaar cliffhanger and its implications for the government and the citizens of this country. That's our top story on Business Tonight.
Unique identity for every Indian. That's what the Aadhaar card intends to do. But in a big setback for the government, the Apex Court today rejected the universal use of the Aadhaar card for accessing services like opening a bank account, getting a new mobile connection or availing old age pensions, thwarting the government's efforts to link the Aadhaar to get benefits under social welfare schemes. This order was in response to a PIL that challenges Aadhaar on grounds of infringing a citizen's privacy, and the Supreme Court has referred the matter to a larger bench. The Apex Court wants the Constitutional Bench to see the merits of the Aadhaar applicability and whether biometric data and iris scan collected for Aadhaar violates the fundamental right to privacy of the citizens. Experts meanwhile insist in absence of enough cyber laws and data collected being prone to misuse.
I think incumbent will be upon Aadhaar and the UID to show how it has gone ahead and complied with the law right from the word go. And if it's still not complied well, I think there is merit in the argument that you should utilize Aadhaar as a broad vehicle for moving forward, but give it on the choice of the people.
The other big problem is that Aadhaar does not have the sanctity of Parliament and was done by just an executive order. And experts say that for the courts to endorse it, it must have the backing of lawmakers in Parliament. But this is not the first time the ambitious scheme launched by the UPA government has run into trouble. In 2013, the Supreme Court had ruled that no services could be denied to a citizen for not having an Aadhaar card.
After the initial hiccups with the Modi administration, Nandan Nilekani convinced them to continue with Aadhaar, a move that had helped in direct transfer and reduction in subsidy leakage. But whether it infringes upon right to privacy, it will be decided by a larger Supreme Court bench. Arun Nayal, ET Now, New Delhi.
Okay, for more on that big story, we're joined by two very eminent legal experts on the show this evening. This is an ET Now exclusive. Harish Salve and Soli Sorabji. Both of them really need no introduction. Mr. Sorabji, I'm going to start off with you. What do you make of the top court decision today, which has not made Aadhaar mandatory for government transactions? How are you interpreting this judgment?
No, the whole question is, please understand, the three-judge bench has referred the issue to a constitution bench, larger bench. Now the application was to modify the interim orders passed by the court. And the court has said, and to my mind rightly, since the matter is before the constitution bench, let them decide to what extent the modification has to be done. So logically, the three-judge bench, having referred the matter to a larger bench, thought it would be appropriate that the larger bench decides what to do about the orders, to modify them or to vacate them. So I don't see anything wrong in that. I think it's quite logical.
Mr. Salve, what do you make of this decision today? I mean, the Supreme Court refused to bite the bullet as far as the universal applicability of Aadhaar is concerned, not to be used in every government transaction as the 5 regulators were wanting it. How do you read this interim order? Because the buck is really with the larger bench now.
You see, Supriya, the problem is it's not that they have done it today. The die was cast when the union government raised the ghost of the absence of a right of privacy to argue that in 2015 you can have a right to life which doesn't encompass a right to live with dignity, and you can have a right to live with dignity which does not have a right to privacy. is taking the constitutional law back into the Stone Age. So I don't think that was the approach to be brought. Now the trouble is, under the overhang of a contention that there is no right to privacy, any constitutional court gets worried when these kind of large issues are raised. And you now have a situation where you have a group of people who are strongly saying that this is going to be Big Brother, nobody is safe, everybody will be under the watchful eye of the government, and on the other hand you have the government saying, hello, where is the right to privacy? So, you know, the whole thing, this application came to be decided under the overhang of a larger issue being raised by the government as to whether is there a right to privacy.
Right.
So that colored obviously the manner in which the court dealt with it.
So what's the position right now, Mr. Salve? Is there a right to privacy? Does it exist?
Well, right to privacy exists. It must exist. If it doesn't exist, our constitutional right to life will be denuded of a very significant aspect. I have argued strongly in the petition filed by Mr. Ratan Tata, and the Supreme Court has heard us at length. The Otto Shankar case recognizes right to privacy. Any number of cases have recognized. One earlier bench had made certain. There was a time where the Constitution was construed literally, but those days constitutional law has evolved and come a long distance. But the Aadhaar card, in my view, the strong argument that the Aadhaar card in no way impinges on a citizen's right to privacy, that was the real point to have argued. And in fact, I argued for the state of Gujarat, saying in the state of Gujarat, please assume that privacy at its highest is available. And we will satisfy you that there is no violation of the right to privacy. And frankly, when I made this point, the presiding judge commented, well, Mr. Salve, if that is what we were hearing, then maybe things would have been different. So the trouble is, this overhang of this larger issue raised by the government as to whether there is a right to privacy is possibly what is coloring everything. I have no doubt in my mind, as a constitutional lawyer, if the matter is heard objectively, the Aadhaar card will come out with flying colors.
All right, flying colors or not, we'll have to wait and watch that. But Soli Sarabji, what's your take on this? Do you believe the Aadhaar card or the whole process of enrollment, because it infringes upon your biometrics and your retina reading, does it infringe upon an individual's right to privacy?
That's the issue before the larger bench, my dear. According to the government, there is no right to privacy involved in this case. There's a dispute on that. Supreme Court judgments are not quite uniform. The three-judge bench also thought that in the view of the importance of the matter, and in view of the fact that there's a slight divergence of opinion whether right to privacy is a fundamental right, matter should go before a larger bench. Now that's before the larger bench. And I think you don't know one thing which I should tell you. I came to know that the Attorney General is mentioning the matter tomorrow before the Supreme Court for the constitution of a larger bench as early as possible. So then the matters will be all resolved.
Fair point indeed, and while he does that tomorrow, the pertinent point also that a lot of people are raising, Mr. Salve, is that the fact that this was done by an executive order and never really had the Parliament's backing, it wasn't a statutory order that went to set up the UID or went to do the Aadhaar enrollments. Is that something that policymakers you believe will have to look into next? Is that a natural consequence of what has happened today?
That's the whole problem. If you explain as to how the Aadhaar card is going to be run, the degree of security, is there a statute which entitles a bank to take your fingerprints? Is there a statute which entitles a commercial organization to take your fingerprints when dealing with you? If you go to a private bank, you go to a foreign bank, forget Indian banks, and they tell you we want your fingerprint, do they need a statute? So this argument is, I'm telling you, it is a specious argument, and the government is not saying that we are making, on the contrary, the government is not saying we have made a law in which every citizen has to line up and give his fingerprint. The government has made a law saying we have created a facility to identify citizens, and a facility by which citizens can prove their identity with ease. If you want the benefits of modern digital age, if you want the security of the digital checks and safeguards for distribution of resources, especially to the weaker sections, you have to find a way of doing it. Why do you need a law?
So, Mr. Salve, the other view is that India does not have enough cyber laws to support Aadhaar being made mandatory. That's a concern that we've heard from some quarters. Do you believe that's a valid concern?
See, first of all, let me try and understand what do you mean by saying India does not have enough cyber laws. The database is available at the Aadhaar server at the union level. If anybody tinkers with this, it's a crime under the IT Act. What more cyber law do you need? And when a government department says, for your identity, please come, I will swipe your Aadhaar card to make sure you are who you claim to be. The only person who would authenticate that is the cyber, or the only facility there is that there is a cyber server sitting somewhere in Delhi or wherever the union government has it, which will in real time respond and say, yes, this person is so-and-so, these are his fingerprints and this is his name. Well, what cyber law are we talking about? It is not that your marital details or your medical history or your brain mapping is being put on the Aadhaar card. For God's sake, it's only your fingerprints and your biometrics for your identity. If this contains details of your marital life or details of your childhood or details of your medical treatment, I can understand all these concerns.
Right, Mr. Sorabji, let you have the last word on this debate then. Are benefits of Aadhaar in a sense over-exaggerated, or is it that the fears around it, are they being overstated? What is your view?
It is exaggerated. But greater push or not push, please enact a law which gives Aadhaar legislative sanction. That's the first basic question to be decided. And of course all the apprehensions expressed, I think they are slightly exaggerated.
All right, get the basic law going and then get the Aadhaar infrastructure in place. Thanks very much. Two of the finest legal luminaries is what I call the two of you, Harish Salve and Soli Sorabji. Thanks very much for sparing time this evening.
Find us on Facebook at facebook.com/ETNow and don't forget to click the like button. You can also follow us on Twitter at ETNowLive. To stay updated with all our programming, hit the subscribe button on our YouTube channel by logging on to youtube.com/user/ETNow.